And I should add, he's not parole, so that makes any difference in your schedule. So he's not rolling.
Good.
Okay, we are on the record. This is the people versus Donald Q. Williams calling case 2260393. Count 1, breaking and entering a building with intent. Count 2, breaking and entering a building with intent. This is individual fourth offense notice. Also, case number 2260395, people versus Donald Q. Williams. Count 1, breaking and entering a building with intent. Individual fourth offense notice. And lastly, case number 2260447, the people versus Donald Q. Williams. Mr. Williams is charged with count 1, larceny in the building, count 2, breaking and entering a building with intent, and also individual fourth offense notice. Appearance.
Yes, good morning, Judge. Richard Lang, 32990, Mr. Williams. Judge, he's not on the camera. He's in custody of my knowledge. He's on parole. There's a detainer, so I waive his appearance.
Okay, just for this proceeding, that's fine.
We can discuss these for an exam, Judge.
Okay, and we do not have the people present, but it's my understanding that there are no issues with discovery. I have February 2nd, 3rd, or 6th. Any of those days work for you?
The 6th,
Okay.
early as possible.
9:30?
That's fine.
Okay, anything else?
That's it. Thank you.
All right, you're welcome. Thank you for coming here. All right, I'm
All right, take care.
Thank you. Okay. Okay, we're gonna handle Gibson and then Sharnita Williams.
Oh, we have Gibson ready to come on.
Okay, Mr. Gerger, I moved a little fast. I didn't realize he was custody.
I'm sorry, Your Honor. Can you say that one more time?
Good morning, first of all. I just started talking to you. Mr. Gibson is in custody, so we have to get him brought
They said.
I understand.
on the camera.
And-
So
and Your
Gibson's
Honor-
gonna handle Mr. Sharita Williams and then Gibson. That work?
That works. Thank you, Your Honor.
We ready on Ms. Sharita Williams?
Yes, Judge, thank you.
Good morning to you.
Good morning.
Ms. Williams, go ahead and unmute your device. I'm getting ready to call your case.
Okay,
All right. So we're on the record. This is the People versus Sharita Williams, case number 2261075. Ms. Williams is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony firearm. Count 3, assault with a dangerous weapon, felonious assault. Count 4, weapons, felony firearms. Designation for a probable cause conference appearance. Actually, there is no prosecutor present yet. If you would like to wait for her, I can recall the case. If there are no discovery issues, we can move forward.
Judge, I just need to get the body camera set to me. And I want to request that 2 officers be brought to the preliminary examination as well.
Hold on one second. I can barely hear you.
I need to, for Ms. Williams, we need to have 2 officers subpoenaed by the prosecutor. And we need to have the digital discovery sent to me.
Okay, so she should be in a couple minutes. You want me to recall it? So I want that on the record. I want her to be able to say what she can do for that, okay?
Okay, yes, that's perfect, Judge. Thank you very much.
Ms. Williams, and go ahead and put your name on the record now.
Sharnita Williams.
Okay, thank you. And I'll recall as soon as the prosecutor.
Thank you, Judge.
You're welcome. For anyone who has a traffic matter in courtroom 332, please log off and Zoom in. The Zoom number is 360-332-000. You'll be with Judge Williams, not Sabree. If you have a traffic matter, the Zoom number is 360-332-0000. Okay, any other attorneys ready on their case? Attorney Schulman.
Yes, yes. Good morning, Judge. I'm here on Zuri Pitts. And we were just going to ask it to be set for an exam.
Okay, any discovery issues? We still have a prosecutor.
I'm comfortable. I made my request and I think I can get it before the exam. I'm fine.
Okay.
I didn't hear
Pitts. He is not, Your Honor.
Okay. Okay, are you waiving your client's presence today for Pitts?
Yes. Yes, I've been in constant contact with him, including last night, and I'm sure he'll probably Zoom in the next few minutes if he's not in the waiting room. But yes, he's aware of today. I'll waive his appearance. If we get an exam date, I will certainly make sure he's aware of that and will be in person.
Okay. We're on the record. Excuse me. This is the People versus Jerry DeQuavius Pitts, 2260976. Mr. Pitts is charged with 1 count of police officer fleeing 3rd degree, stated except for a probable cause for appearance.
Good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of Zuri Pitts. Mr. Pitts' appearance, we waived that. I've been in constant contact with him, and we're asking the court for a in-person preliminary exam date.
Okay, I have the February 2nd, 3rd, 6th open. Do any of those days work for you?
Yep, February 2nd. The 3rd is the only bad day, but February 2nd is good. So,
Okay, let me get a time for you.
okay.
Okay, so
8:30 works.
anything between 9:30 and 11 o'clock, you can take your pick.
What's the earliest?
9:30,
Okay, 9:30.
okay. Anything else?
No, thank you. We'll see you on February 2nd.
All right, see you then. Have a good one.
Thanks.
Okay, we have someone calling in from the Wayne County Jail. Unmute and state your name, sir. I need you to unmute your device. From the Wayne County Jail, sir, I need you to unmute so that I can get your name, please.
John Robert Gibson, the third.
Okay, your attorney is here. Attorney Gregory, do you want to speak to them in private in the breakout room, or are you ready to go?
No, Your Honor, we are ready to go.
Okay.
Good morning.
Excuse me, sir.
Jackson, I believe you
district-
have a traffic matter. Devon Jackson, do you have a traffic matter?
Yes, the Detroit district sent me to the wrong thing. They gave me the wrong ID
Just
thing.
listen, I need you to listen. If you have a traffic matter, you should be in 332 with Judge Williams.
I tried that. They sending me to the wrong, they giving me the wrong information.
Can I give you the right information?
I'm missing my court date and everything.
Are you ready to get the right information? We have some cases. We're in the middle of, Mr. Jackson. I want to get you to the right courtroom.
All right, yes. Can you just send me to it,
Send it to what?
to the right courtroom?
No, you have to log in.
All right, I'm about to write it down because she gave me the wrong information. It's wasting my time.
I'm gonna put it in your chat. We're in the middle of something right now.
Pardon me? Hold on.
We're on the record, this is the People versus John Robert Gibson, case number 2256948. Mr. Gibson is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carrying concealed. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. Today is the date set for a probable cause conference. This is also a habitual offender, second offense notice. Appearances.
Good morning, Your Honor. Daniela Claire on behalf of people P85495.
And good morning, Your Honor. Austin Gregory on behalf of Mr. Gibson, who is present via Zoom, P85193. Mr. Gibson, one more time, will you state your name for the record?
John Robert Gibson, the third.
Thank you. Good morning, everybody.
Good morning.
Okay, and we are here today for what? I have oh, yes, probable cause conference. Okay. Any issues with discovery?
No, Your Honor, we are ready to proceed with the preliminary exam.
I have a date here for the 19th. Is that what you have, Mr. Gregory?
That is what I have, Your Honor.
Okay, does that date still work?
Yes, it does, Your Honor.
Okay, does it work for the people? Did we set a time?
We had not, Your Honor.
Okay,
We
How about 9:30?
that works, Your Honor.
For the people?
Yes, Your Honor, thank you.
Okay, anything else?
Nothing further, Your Honor.
Okay, you're all set, Mr. Gibson. I will see you on the 19th.
Okay, thank you.
You're welcome. Have a good day. Okay, next we're gonna call Sharita Williams. Okay, we're on the record. This is a recall, Ms. Sharita Williams, 2261075 appearances.
Good morning, Your Honor. Daniela Claire on behalf of people P85495.
Good morning, Judge. Patrick Nineheis, P76343 on behalf of Ms. Williams, who's present via Zoom. We consent to a Zoom hearing today.
Ms. Williams, one more time, please state your name for the record.
Sharnita Williams.
Thank you. And is it correct, counsel, that you have some issues or questions about certain discoveries?
Yes, Judge, thank you. Right now, I have received the paper discovery, but I'm asking for the officer's body camera. And I would like to have Officer Rock and Officer Hernandez present at the preliminary examination as defense witnesses.
Well, you can, may I address, Your Honor?
Go ahead, people.
You can email me directly in regards to any discovery issues. If, are you stating that you did receive digital, but what the digital that you received failed?
I
to
received
have-
paper discovery, no digital yet.
You could email me, sir, if you do not have it by the end of today. That I will reach out to the OIC. My email is D as in David, P as in Patrick, E as in Edward, R as in Robert, I as in Igloo, C as in Charles.
Thank you very much.
If the people intend on calling those witnesses for the preliminary exam, obviously we would be subpoenaing them today. If they are not, you'd be obligated to subpoena them yourself.
Okay, so you're not gonna help out? That's great. Thank you.
But I didn't say I wasn't gonna help out, I don't know who we're subpoenaing yet, so I can't really tell you.
Right, you're subpoenaing two civilians, and those and the officers actually observed the.
Sir, I don't know how you can tell me who we're subpoenaing. Again, if we need them for the preliminary exam, because it is a probable cause standard, we do not subpoena every witness for the preliminary exam, sir. If we subpoena them, they will be here. If you want to actually subpoena someone because you want to put their testimony, you can go ahead and do that. As of right now, I do not know who we're subpoenaing for the preliminary exam. If you'd like to reach out to me to discuss that further, you can.
Thank you. I'll send you an email right now. I appreciate it.
Are we ready to set a date for the exam?
Yes, yes, Judge. We'd like it as soon as possible. It was originally scheduled for the 19th. Can we keep that date?
We can, actually. Let me get a time for you.
Your Honor, I would just like to note that if there is any issues with discovery, because it is the 19th, I understand he wants it as quickly as possible, but he is aware as are the people that as of right now, we have a discovery issue, at least based on what the information defense is given. I will try to speed it up to get it resolved. We can contact my carrier tomorrow, but I would just like to put it on the record that the 19th is pretty quick. If there is a problem, the defense needs to reach out to us prior to that so that we're not adjourning on the day.
So it was just digital or body cam?
That's what he has stated, yeah.
Okay. Do you think that that's enough time to get the body cam?
I will email the OIC today, Your Honor.
Okay, so we'll stick with the 19th, and if for some reason in between we get information, we'll set it for the next closing date, right?
Thank you, Your Honor.
Thank you, Judge. What time on the 19th?
How about 10 o'clock?
That works perfect, Judge. Thank you very much.
You're welcome. Anything else?
Nothing further, Judge.
Okay, you'll have a good day.
You too.
Ms. Williams, you're all set. I will see you on the 19th in person.
Okay, thank you very much. Have a great day.
You as well.
Mhm.
Attorney Dillard,
Yes, good morning.
good morning. How are you?
Pretty good. I'm calling in regards to Chavez Ferris, which was up for on the 9th. He failed to appear. Bench warrant was issued. I've been in communication with him. I'm asking if we can come in on Zoom today to lift the bench warrant and reschedule a pretrial.
Let's see, what time would work? Is the traffic case good? Is this showing up? Actually, Attorney Dillard, I believe this is a traffic matter.
It is. I know initially you were down on it I'll go and check the register of actions and see who's the judge on this case now.
I can tell you, it's Judge Williams in courtroom 332.
Okay, Larry Williams. Okay, thank you very much. Have a great day.
Madam, Madam Clerk? Madam Clerk?
Good morning.
Madam Clerk, were you able to hear me?
We were on the record, sir. Can we help you?
Okay, I have Johnny Dickerson.
In the middle of a matter on the record, so I muted you.
Okay.
Oh, I don't have something different there. Okay, so you said Dickerson? Yeah, it's. Davion Jones,
Yes,
good morning, sir.
I had a court date today at
Good morning,
8:30.
sir. Good morning.
Yes,
You have a traffic matter?
say it again.
Do you have a traffic matter this morning?
Yes.
Okay, you should be in courtroom 332 of Judge Larry Williams.
Okay, I was trying to get in, but I was sitting there for a minute and no one would let me in.
Well, you need to wait until they let you in.
Okay.
Do you have the right Zoom information?
Yes.
Okay, just wait in the waiting room, they'll let you in.
Wait, you said, because when I put my Zoom number that they gave me in, it came up yours.
I just sent you the correct Zoom information in the chat. It says you haven't switched it. So the problem is we've switched dockets, so it says my name still, but it's really supposed to be Judge Williams. So 360-332-0000.
Okay.
Just hold tight, they'll let you in.
Madam Prosecutor. Madam Prosecutor. Yes.
How are you? Good.
Okay, we're ready on Mr. John Dickerson.
I didn't CC you on it, but I sent her noticing. You got to be specific, and I told her. We set that date because remember she sent a thing and she didn't even zoom in. She just sent something to us.
Mr. Jackson, put on a shirt, please.
I'm doing it right now. I apologize.
You- I said, she did zoom.
Okay, you should be in courtroom 332 for a traffic matter.
Yes, ma'am.
You're in the wrong courtroom. 360-332-0000.
That's what I put in.
No, you're in 438 right now.
It says, okay.
Telling you you're in the wrong courtroom.
Okay, I'm gonna try to put it in again.
332. Do not do it for the Zoom link on our website. Do it with the digits that I just sent you in the chat. 360-332-0000. Okay?
Huh? I'm trying to, so chat, hit one. Okay, 360, okay. 332, okay.
Yes, it's courtroom 332.
Okay, so I'm gonna try, so put that information in, go back and put that in.
Yes, log off to this courtroom, it's the wrong courtroom. I switched courtrooms and dockets, so people are confused about that. You should be with Judge Williams now, in 332.
Okay, I'm about to put it in now.
Okay.
That's it, because I sent her something since then. I'm forward it to you.
Okay, to the gentleman in the Wayne County Jail, can you unmute your device, state your name, please?
You want you to say your name,
My name is Donald Williams.
Donald Williams. Okay. Mr. Glenda already took care of your matters. He just needed a date for your preliminary exam. You have a date scheduled for, give me one moment, I have to pull your file. 6 and 9:30. Okay, so your preliminary exam will be February 6th at 9:30, all three of them, all three of your cases.
Okay, ma'am, how can he handle this already when I wasn't even arraigned on case number 1? And this is what I've been telling him. I wasn't arraigned on case number 1 in the prescribed time frame. My case was never, if you look at it, it's in the record. I was held at the Mound facility, and I never been arraigned on case number 1. This case is supposed to be dismissed, case number 1. And that's what I'm here for.
This is the assistant prosecutor here in the courtroom. Our records indicate, sir, that you were arraigned on November 3rd on I'm looking at only one of the cases that ended 395.
Ma'am, I sat in the mouth.
What you're not gonna do is talk over people. So I need you to listen first, and then I'll give you a chance to respond.
As I was stating, sir, it says November 3rd, that you were in front of Magistrate Laura Acartia, and that you stood mute and pled not guilty. I have no further information here on that.
Look at my arrest date. Look at my arrest date and look at the date that I was arraigned and tell me that falls within what was prescribed by MCR 6.104.
Mr. Williams?
Yes.
You are in custody for 3 cases.
Wait.
Hello?
Yes,
Yes.
you're in custody for 3 cases.
Ma'am, how can I, when I was held for over 7 days and I wasn't
I will make sure that you've been arraigned on all 3 cases, so just hold tight. I'm gonna check your file. You're muted, so you can't talk over me. You're muted. So you can keep talking, but I can't hear you. So we will check on your 3 files and make sure and give you the date that you were arraigned. So just hold tight. You need your 3 files back there? Corporal Slidell, good morning. Corporal Slidell, I think you're in the wrong courtroom. I'm on felonies now.
Okay, I'm sorry about that. Do you know the correct courtroom for Judge Williams traffic court?
Yes, 332, it's the same courtroom, 332, so 360, 332, 0000.
Okay, thank you.
Have a good one.
You too.
Okay, let's handle Devin Lee. Both parties are already on that.
Good morning, Your Honor. I am representing Mr. Lee. My name is Alexandra Chode. I'm an attorney with NDS.
Okay. Okay, we're on the record as the people versus Brandon Devin Lee, case number 2260935. Mr. Lee is charged with count 1, weapons, dangerous weapons, miscellaneous. Count 2, operating with a high VAC. This is the habitual offender 3rd offense. Notice that's for a probable cause conference today. Here.
Good morning, Your Honor. Daniela Fairchild, behalf of people P85495.
Good morning, Your Honor. Alexandra Cho with the Neighborhood Defender Service of Detroit, P85948. On behalf of Mr. Brandon Devin Lee, there has been an error in his name as it appears on the record. His name is Devin Lee. Brandon was an alias that I believe had been used years and years ago, but his name is Devin Lee.
Okay, I have that as his alias as Devin Lee, but I'll make note of it.
Perfect. Thank you, Your Honor.
And Mr. Lee, can you state your name for the record, please?
Devin Lee.
Thank you. And do we have any issues with discovery?
We are still missing the digital discovery, Your Honor. We are requesting that that be sent to our office and the case be adjourned until we receive it.
I'm sorry, this is A. Danielle Parrish. I just wanted to confirm what I was about to say, but my computer is moving a little slow. So I will say it. Here's that digital was sent via evidence.com. I want to check the date for you. You could just double check on your end if it was received by you, or if they have been sent. Again, I apologize. My computer is moving slow and it's not pulling it up here. If there is a problem, if you could directly email me today, because I am aware that we are in receipt of some sort of digital. I can't remember exactly what kind, but I'm happy to resend it to you today. If you wouldn't mind just emailing me this morning, and I'll get it over to you again this afternoon.
That would be perfect. Could I get your email really quick to jot down?
It's D as in David, P as in Patrick, E as in Edward, R as in Robert, I as in Igloo, C as in Charles, at waynecounty.com.
Perfect. So, Your Honor, I can email to see that discovery, also double check if we have it. I would still request that another PCC be set. But if Your Honor would be sitting a preliminary exam, I would just ask that be pushed a little bit further in order to get that discovery or locate the discovery.
We're already in February, so I'm inclined to just set an exam date, and if there's an issue, you can call the court and we'll change that to the PCC.
That would be perfect, Your Honor.
Okay, so we're at February 2nd, 3rd, and 6th as the earliest date.
Your Honor, if we could do the 2nd or 3rd, Mr. Lee, if you have a preference.
Let's do the 6th. We have everything. We have between 10 and 11:30 open.
Okay, if February 2nd works for you, so Mr. Lee, that would be perfect for me.
Okay.
Ms. Choate, you said 2nd, right?
Yes, February 2nd.
Okay, so that would be 10 o'clock work?
That would be perfect, Your Honor.
Okay, February 2nd, 10 o'clock in person, Mr. Lee.
Okay.
Thank you, Your Honor.
Anything else?
That is it, Your Honor.
Okay, you want to take that?
You too.
Ms. Aaron, go ahead and unmute your device, please.
Can't hear.
Okay, I'm unmuted.
Good morning. What is your full name?
Aaron Jones.
Are you here for a traffic matter?
Yes.
Okay, you're in the wrong courtroom.
Oh.
Judge Williams is handling my case. We switched documents. So the Zoom information I'm going to put in your chat so that you can log to the right courtroom.
Okay, thank you.
I just sent it. Did you get the numbers?
Yes, I got it. Thank you.
Okay, so log in if they have issues telling that you were in the wrong courtroom.
Okay, thank you.
Ready. You ready to go?
I'm ready on Johnny Dickerson for Capias, Judge.
Okay. This is the people versus Johnny Dickerson, calling case number 2261032. The people versus Johnny Dickerson. Mr. Dickerson is charged with 1 count of stolen property, receiving and concealing a motor vehicle, set for a probable cause conference at 8:30 today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people P85495.
Elliot Margolis, P28078, on behalf of Johnny Dickerson. I've had no contact with Mr. Dickerson, Judge. I previously wrote him a letter asking him to contact me. He has not responded. I also requested discovery, but I guess that's a moot question at this point in time. He has not responded to me.
My apologies about the discovery. You are correct. I do have discovery for you. But my apologies. We had a different attorney originally. If you could give me your key number and correct spelling of your last name, I'll have the discovery today.
Okay, but
Go ahead.
okay, my P number is P28078, but I have had no contact with Mr. Dickerson.
Based on this information, the defense said no contact and has attempted people with for capias.
Okay, now number 2, I will issue a capias personal bond with $1,000.
Okay, and if you can just note me as the attorney of record, Judge.
I'm sorry, I can't see. What's the last name?
Margolis.
Thank you.
Yes. I will do so.
Thank you. Thank you very much. Have a nice day.
You too.
No, that's what they do.
So the person dialing in with the digits ending in 0810, can you state your name, please?
Marcel Foster.
Mr. Foster, I've been trying to chat you and message you. You're in the wrong courtroom.
Oh my God. Oh my God.
The link they gave you.
I don't know what I'm doing.
It's fine. Judge Williams is now taking over the traffic docket for 332. So write these numbers down. We'll just listen, just write the numbers down. And I'll give you the court phone number too, so you can call, okay?
Okay, give it to me.
360-332-0000. The phone number you can dial in is 965-2285.
2285.
That's 313.
Yes, 313. So Mr. Foster, if you have problems logging in on Zoom, call that 313 number and the clerk in the right courtroom will guide you on how to log on to Zoom in their courtroom,
Thank you.
okay? And
Thank you.
It's in the wrong courtroom, okay?
Okay. All right. Thank you.
You're welcome. Have a good day.
All right. Bye-bye.
Put in a request with IT today. Okay.
Hello, is anybody in here?
How can I help you?
Yes, how are you doing this morning?
I'm doing well. How are you?
I'm fine. I am confused at this point. I had a ticket and it had this Zoom on there for 8:35 this morning for Judge Aliyah Sabree. And then someone told us to join Zoom 360-332-0000. So I've been on there waiting to be let in by the host for over an hour now. So I'm just trying to figure out what's going on. Is the judge in yet, or I've literally been on there over an hour. I've called down to the 36th district twice. They gave me the courtroom phone number. Yes.
So you need to, is this for a traffic matter?
Yes.
Okay, so you have to wait until the host lets you in.
Okay, so just wait. It's not like this one where you just automatically in. You have to just sit there and wait.
These are two different courtrooms. This is a felony courtroom and you're checking into a traffic courtroom. Traffic is a little bit more hectic. So you have to wait until the host lets you in.
Okay, even if it takes hours?
I don't know what the docket looks like. It could be a very heavy docket. So you have to wait until the host let you in.
Ms. Dominic, this over 100 cases, traffic handled today, so you just have to wait. You will be heard.
Okay, I'm glad I took off work. Thank you so much.
Okay, I'm going back on mute. Serena,
Yes, ma'am.
did you okay?
I'm good, thank you.
Okay, all right. Let me know when you're done, then I could, check that for you right quick.
Okay, sounds good. Thank you.
Okay, all right.
Okay, we're on the record. This is People versus Darren Torrey Abbott, case 226032. Mr. Abbott is charged with count 1, weapons carrying concealed, count 2, felony commission with the motor vehicle adult advisory. Today is the date set for a preliminary examination. Appearances.
Good morning, Your Honor. Daniela Pierce on behalf of People P8495.
Good morning, Judge. Neighborhood Defender Service of Detroit by Carrie Martin, P84592, appearing on behalf of Mr. Darren Abbott. Mr. Abbott, would you please state your full name?
Darren Torrey Abbott.
Good morning, everybody. And are we ready to proceed?
Yes, Your Honor, people are ready to proceed at this time. I would indicate that the OIC who is not testifying is in court.
Any objection?
No, Judge.
Okay, so people can.
Thank you, Your Honor. People call Officer Paul Greer.
Go to court first, and then I'll swear you in. You come first. Stand right here. Make sure to tell the truth, the whole truth, and nothing but the truth. Okay, let's see. Make sure you see that.
I'm going to ask you a series of questions. If you could kindly, and I see the prep, thank you, just speak into the mic with your answers. If there's something I ask that you don't understand, just stop me and I'm happy to rephrase. Would you mind just please state your name for the record, sir?
Officer Hawk Greer,
And officer, where are you currently employed
Detroit Police Department,
and in what capacity?
as a police officer,
How long have you been a police officer?
3.5 years.
Were you employed in this capacity on October 27th, 2022?
Yes,
You by yourself that day or with partner?
partners, with partners.
Could you tell us your partner's names, please?
Officer Darwin and Officer Jenner.
Thank you.
You said the first officer's name again?
Darling,
Officer, were you in a scout car on that day, sir?
yes,
Was it fully or semi-marked?
semi-marked.
What does that entail?
It means that the letters are reflective. When it's light hits it, it reflects the letters. And also it matches almost matches the color of the car, but it's still visible when light hits it.
There's police.
Yes,
indicated.
police is good, yes.
Were you in full or modified uniform on that day, sir?
Modified,
And could you tell us what that is?
meaning I wear green pants, tactical vest, and a uniform shirt, a t-shirt or sweater.
Does your vest indicate police on it as well?
Yes,
Sir? Your duties as a police officer take you at or near 1700 East 7 Mile Road in the city of Detroit County of Wayne?
yes.
Can you tell us why you're at or near said location on that day?
I did conduct a traffic stop.
Were you on routine patrol on that day, sir?
Yes,
While on patrol, did something, you observed something that drew your attention?
yes, I observed a vehicle with no insurance.
As a result of your observation, what if anything did you do, sir?
Conducted a traffic stop,
Do you recall the type of vehicle it was, sir?
Chrysler 300. Black Chrysler 300.
When you say the vehicle did not have insurance, was this verified and lien?
Yes,
Did you or your partner
Your
approach?
Honor, I'm, pardon the delay, I would object to him confirming the verification of the lack of insurance and lien on multiple grounds. First, that we haven't established that it was he himself who checked lien. Second, lien results in of themselves without the results physically being brought to court would be hearsay. Testimony as to lien results are hearsay. So both, it's layered hearsay in that he wasn't the one who checked, and he's testifying to a record that has not been provided in court today.
Your Honor, the people just indicate that, first of all, it is a fact on the listener as opposed to being hearsay. We're not hearsay the truth of the matter asserted. This is just the reason why the vehicle was stopped. If defense would allow, and Your Honor would allow further questioning, you will see that the officer himself actually conducted an investigation to get this information.
So first, we don't know if it's hearsay because he hasn't, so we haven't gotten there yet. I will allow you a cross to explore that. And as far as saying the lead information on paper, even the officer can search on computers that sufficient that information. But we haven't gotten there. So I will allow you a cross of course to explore.
Also, did you or your partner approach the driver after you initiated a traffic stop?
I did.
Okay. Is the driver of that vehicle that you approached in the courtroom today, sir?
Yes,
Can you indicate where that individual is and identify an article of clothing that they're wearing?
sitting in the first row on your right, the review with a brown vest and a black sweater underneath.
Thank you, Your Honor. May the record reflect the identification of the defendant, Darren Abbott, please?
So reflected.
Thank you. So if you could please tell us what transpired between yourself and the defendant when you initiated your initial contact with the driver?
I approached the driver. I stated to him why I pulled him over, to no insurance. I asked him multiple times to step out of the vehicle. He was very argumentative and refused to do so after multiple times asking.
Sir, so if you don't mind, I just want to back up a little bit. So you indicated that you conveyed to the defendant why you pulled him over.
Yes,
Did you ask for, did you investigate further? Did you ask him for any information?
yes, I asked him to produce insurance.
Did he provide you with insurance?
No,
Did you give him an opportunity to look for insurance? How quickly you stated that you asked him to step out of the vehicle? Did he have an opportunity to look for the insurance?
yes,
Okay. At any point in time, did he provide you proof of insurance?
no,
What did you do based on that information that he did not provide you insurance?
I advised him the vehicle is going to be towed for no insurance.
Okay. After you advised him that the vehicle would be towed, what if anything occurred then?
He refused to step out of the vehicle.
Did you you say he refused, so I assume you gave him an order to step out of the vehicle?
Yes, multiple times.
Multiple times, sir? Okay. Did you eventually get the defendant to exit his vehicle?
Yes,
What happened after the defendant eventually exited the vehicle?
I had him step in front of my scout car.
Sir,
What did you say? I didn't hear.
I'm sorry, I had him step in front of my patrol vehicle.
what, if anything, did you do next, sir?
I then conducted an inventory search.
You stated this for a search, you searched the defendant's vehicle prior to the impound?
Yes,
You conducted this search yourself, sir?
yes,
What, if anything, did you recover from the defendant's vehicle during the search?
We recovered a black handgun between the center console and the passenger seat.
And I'm sorry, I didn't hear the beginning of that. What kind?
We recovered a black Springfield XDS from the center console and the front passenger seat.
Sir, this Springfield, just for recording purposes, is this a handgun?
Yes.
How far is this location that you located this Springfield handgun from where the defendant was seated when you made contact?
Very close proximity.
You said it was between the center console and the passenger seat?
Front passenger seat.
Do you recall if the gun was loaded, sir?
Yes.
Yes, it was?
Yes.
The course of your investigation, did you have an opportunity to find out if the defendant was a CPL officer?
Yes. He was not the CPL holder.
Also, in the course of your investigation, did you find out if the gun was registered?
Yeah.
Was it?
I don't recall if it was registered.
One final question, sir. Was your body worn camera working during this incident?
Yes.
Further questions? Thank you.
Morning, officer. I have some questions for you.
Good morning.
So on this day, October 27th, you were driving your squad car, correct?
Yes.
And it was your partner, Officer Darling, in the passenger seat.
Yes.
So you were not on your squad car's computer, were you?
No, I was able to see it.
You were able to see it. So it was Officer Darling who was making the search on the computer.
Yes.
And Officer Darling notified you verbally of the results of the lien search that he made?
Yes, and also saw it.
Did you bring those results to court today?
No.
And was there any basis for stopping Mr. Abbott's car beyond the results of that lien search?
No, just the insurance.
Just the insurance. And you stated in your report that you stopped Mr. Abbott in order to investigate the vehicle for further proof of insurance. Does that sound right?
Yes.
So at that point, you had a suspicion that the car lacked insurance.
Means that it has no insurance, so therefore I verify it by stopping the driver and asking for proof.
So it's fair to say that you needed further proof from the driver of whether or not he had insurance at that time.
Yes.
So at the time you stopped Mr. Abbott, you and multiple officers surround his car.
Can you just
So I'll be more specific. You approach the driver's side of Mr. Abbott's car.
Yes.
And there were two other officers who approached the passenger side.
Myself approached the passenger, myself approached the driver's side, and I don't know where they were positioned.
but they being Officer Darling and Officer Jetter,
Yes,
they were outside of the car, they were near Mr. Abbott's car as well.
yes,
And you were all wearing. You asked Mr. Abbott to roll down his window as you approached?
I believe so, yes.
Yes. And you looked through the window
Yeah, through the window,
when he rolled down his window
Yes.
on your request.
Mhm.
And after he did that, did you look through his car window?
yes.
And what was the purpose of looking through that window? Did you ask him to roll down his window so that you could inspect?
Just so I can
the
talk,
weapons?
so I can speak to him. He can hear me.
But you asked him to roll down his back driver's side window, is that correct?
Yes,
And did you do that in order to inspect the car for weapons?
I did it to see who all was in the vehicle.
And did you have a flashlight on you?
Yes,
So you did look through that window,
I couldn't, it was heavily tinted.
but he had rolled down his back.
Eventually, yes.
And at that time, you had not seen any weapons in plain sight.
No,
So when you start speaking with Mr. Abbott, you immediately asked for his license, registration, insurance.
yes,
He provided you his license.
yes.
He provided you his registration.
I don't recall if he gave me his registration.
And after he gave you some papers, he was continuing to look for other papers.
Yes, for the insurance.
At one point, Mr. Abbott said of his insurance, it should be there.
I don't recall verbatim what he stated. But I gave him ample time to produce it. He failed to do so.
When you say ample time, does about 4 minutes sound accurate?
Approximately,
Approximately 4 minutes between the traffic stop and Mr. Abbott's arrest.
I don't recall the exact time, but I asked him for insurance. He began looking through the different compartments. He stated it was in his phone, he did not produce it in his phone. So at that point, I decided, yeah, the vehicle was going to be towed.
Yeah.
Because he was the insurance.
Hawkins and
Did
the
he
young lady
ever
too.
state that he did not have
And
insurance?
Mr. Pope.
I don't recall if he didn't state he did not have insurance.
He never made an admission or a confession that the car was uninsured.
I don't recall.
Officer Greer, you had asked Mr. Abbott to step out of his car,
Yes,
and then shortly after this, you opened his car door on your own.
yes,
Yes. And one of the officers on the other side opened the passenger door.
I don't recall what other part did.
Mr. Abbott told you that he was trying to log into his Geico account to find his proof of insurance.
I observed him looking, trying to look through his phone to find it. Never found it.
And when you eventually had Mr. Abbott, you did eventually have Mr. Abbott step out of the car
Yes,
and you placed him in handcuffs.
I personally did not place him in handcuffs.
Okay. Did you see him being placed in handcuffs?
No,
Can you confirm that he was placed in handcuffs?
he was detained. The partner, he walked into the rear of the car. And, after my inventory search, he was, in the rear. I saw him handcuffs.
And do you recall whether Mr. Abbott was holding his phone as you took him out of the car?
I don't recall this on his phone.
You don't recall whether he was calling someone trying to find proof of insurance still?
Remember you saying he wants to call someone while he was in the vehicle.
And officer, you didn't write Mr. Abbott a ticket for driving without insurance.
I did, no.
And as far as you know, Mr. Abbott is not charged with driving without insurance.
I can't speak to who wrote the ticket. The ticket was written, but I didn't know who wrote it.
Oh, so you say a ticket was written,
Yes,
but you never saw that ticket?
I did see the ticket.
But that was just do you recall what that ticket was for?
Insurance.
Did you note in your report that he was ticketed for driving without insurance?
No.
I did not see. And at the time that Mr. Abbott was placed in handcuffs, had a firearm been found yet?
Your Honor, I'm going to check based on the previous answer from the witness who indicated that he didn't actually observe the moment when he was placed in handcuffs. He indicated that after he did the search, he saw that the defendant had been in handcuffs, that he himself didn't place him in handcuffs.
I'll withdraw the question. And at this time, I would like to play a few minutes of the body cam, as there are certain timeline issues that Officer Greer has not been able to answer, and then I'll conclude. Now, last time I did this, I shared my screen. It didn't work very well, so perhaps if I can just approach and play a few minutes. Computer here. Play about the first 3 minutes of this video. Thank you, Judge. Officer Greer, I know there's not much you can see yet, but do you recognize this footage so far?
Yes.
Is this your
Yes.
Is this your body worn camera from October 27th, 2022?
It appears to be.
Oh, I was asking, if you could indicate on the record.
Video stops exactly 5 minutes. Thank you, Judge. Thank you for your patience. Now, just a couple follow-up questions, officer, and then I'll conclude. And to confirm, you did recognize that video as your body-worn camera from the day of Mr. Abbott's arrest?
Yes,
And at any point during that video, did you hear Mr. Abbott confess or state that he did not have insurance?
I did not hear him say it.
And did you hear him saying that he did have insurance on the car?
Yes,
How are you moving it?
I will admit the video. Nothing further.
Can you redirect? Just to clarify, I know we all just watched the video. Do you recall how many times you had to tell the defendant to exit his vehicle due to the fact that you're impounding the vehicle?
numerous times.
More than 4, more than
Yes.
5?
Yes,
I believe, and just because we couldn't hear it clearly, so if you could clarify for us, we heard the defendant respond, but I didn't hear you clearly in regards to a resisting charge.
yes,
Did you
I
indicate that to him?
advised him at that point he was resisting.
And from that point, as we recall, do you recall how many times he still did not get out of his vehicle?
A couple of times after that.
All right, and just lastly, is it an impoundable offense if you don't have proof of insurance to provide?
Yes.
No further questions.
Briefly.
Officer Greer, you did not have to use physical force to take Mr. Abbott out of his car, did you?
Physical force meaning,
Meaning you did not have to use strength to pull him out of the car.
no,
He did step out of the car.
yes, with my guidance, yes. Yes.
No further questions, Your Honor.
Officer Greer, thank you. Any more witnesses from the people?
No further witnesses from the people, Your Honor. Thank you.
Any witnesses for defense?
Nothing from the defense.
Argument from the people?
Your Honor, I do want to put on notice at this time, based on the information and the video that was played during the preliminary exam, the people are adding an additional count of resisting and obstructing a fellow officer. And we move that defendant Darren Abbott be bound over on count 1, weapons carrying concealed, and count 2, resisting and obstructing an officer, and we reserve argument at this time.
Reserve argument for me to address the additional charge or reserve argument until counsel?
To both, to the bind over, Your Honor.
Okay.
Thank you, Your Honor.
You know, you're ready.
Yes, Your Honor. Mr. Abbott stopped, and everything that came after was not, there's no admissible basis for his stop. All we heard is that Officer Greer's partner made a lien search and found proof of insurance, or lack of proof of insurance in lien. That is layered hearsay. The first level of hearsay being that Officer Greer says that he was told this information by his partner. But the second and more important layer of hearsay being that the testimony about the results of lien searches in themselves are inadmissible hearsay. In fact, right here, I have a printed copy of a recent decision by Judge Knapp of the Third Circuit Court, finding just that. In a similar case involving a stop based on lien results for lack of insurance, he found that testimony about the lien results was inadmissible hearsay, and he suppressed the firearm that was found as a result of that stop. I asked this court to make the same finding in this case. Furthermore, the charge that Ms. Parrish moves to add, the resisting, that is also the result of an impermissible stop based on inadmissible evidence and nothing further. Where I'll restate that Officer Greer said there was no basis for the stop other than this result that his officer found lien, and that any conduct that may be deemed resisting after that fact is the fruit of an unconstitutional stop, or a stop that cannot be the basis for which cannot be admitted here. Furthermore, there's no physical force that ever needed to be used against Mr. Abbott. After a few minutes of searching for his insurance, he stepped out of the car without force applied by any officers. That's, of course.
You don't need that.
And sorry, I only have one copy.
Counsel, are you familiar with?
I'm not familiar with this case, Your Honor, and I apologize. I'm not familiar with the case, nor do I know if the actual factual basis of that case and what occurred in that case is the same type of situation as this current case.
It's a very recent opinion, and the facts are remarkably simple.
You know your argument?
I am.
Okay, give me one moment while I read this. I'll let prosecutor review. this being a case from Judge Knapp that council referred to in the argument.
Thank you. May I approach? Yes.
Thank you. Excuse me, Judge, that's too late. Thank you. This is a- Thank you. Okay.
I don't believe I have to read all of this, just from the beginning incident. I have an argument that this case is not indicative or the same as our case. I do understand defense's argument. However, in this case, the officer directly goes to the driver and tells him, on quote on here, it says that he just walked up to him and said, you could do an inventory, that to step out, he's doing an inventory search. As we watched in this video, that is not what happened. Even though in the past, we have always used lien. Lien is a probable cause reason to be pulled over. This officer did not use lien as his sole reason to search the defendant's vehicle. It was the reason he pulled him over, yes, and there is no argument against that, and not in here either. However, the argument is, did he go directly and search? And this officer in our case did not do the same as Officer Canada in this case. He did not immediately tell him to get out. As we witnessed, he asked him immediately, he asked him, do you have insurance on the vehicle? We watched as the defendant tried to find insurance, and it was a while as during cross was the officer was asked how long it took. It took a few minutes. He gave him a few minutes to look. And in the end, the defendant was unable to provide insurance, which is a towable offense in Michigan. Your vehicle can be towed, and he was asked to get out of the vehicle several times, as we witnessed and as the testimony indicated. I believe that is different than this particular case, where the officer just went on lien and walked up and said, get out of the vehicle, we're searching. Before you respond,
So to the people, my question is, in paragraph 2, we're discussing these facts do seem pretty similar, actually.
I'm sorry, Your Honor, we're talking about page 1, paragraph 2?
Yes, I'm sorry.
Yes.
So it says they initiated a traffic stop on a silver Volkswagen due to the vehicle being uninsured. Officer Canada testified that it was his partner who checked in and informed him that there was no insurance on the car.
And that also is a little bit, I'm sorry, Your Honor,
No, go
I
ahead.
didn't cut you off. That's a little bit also different, because our officer, granted, he did on cross indicate that his partner did the search because he was driving, but that he saw in lien himself. So he didn't just go based on the information that his partner, told him, but he also saw it on lien, which is a little bit different than this as well.
And then the next sentence says the defendant pulled the car into a public parking lot and was legally parked at the time. So I just wanted to clarify that the facts are very similar, that a lien search was done while the defendants were driving and the partner was the one who did the search. Just for the record. Mr. Martin, do you have anything? Well, actually, I should say, Ms. Perry, are you done with your argument?
Well, and this, if I could reserve my argument for the bind over, I was just arguing that I don't believe that this, because of those two factual differences, I can continue at the bind over, and I'll allow defense to answer what we just discussed.
Okay.
In response to Ms. Parrich's notes about the case provided, yes, the case does, Judge Knapp ruled in this case on 2 grounds, and one of those was about when an inventory search is permitted. But the other most relevant ground to this case is whether testimony about lien results is admissible or is hearsay. And the fact is, it's hearsay. And what we have, even if we take Ms. Officer Greer at his word that he had seen the lien results himself after Officer Darling showed it to him, his testimony about those results is hearsay. If they brought in the lien results themselves, that could be admissible as a business record, but there are no business records in this case. There's no proof beyond hearsay testimony of lien saying that Mr. Abbott lacked insurance. And as Officer Greer testified, there was no other basis for the stop. There is no admissible basis for this traffic stop. And therefore, everything that followed from that must be suppressed. The case must be dismissed.
Your Honor, I'm just wanting to understand, it seems like there's little nuances here with this. I am happy that defense has brought this new case up, but there's little nuances that I do not know if clarified or defense wants to clarify. I do have a question in the fact that is the argument that it is hearsay because the lien record was not brought in, or that because a partner checked the lien?
I would clarify that it's your first point, that the lien record was not brought in. Testimony about lien results for a judge now is hearsay. And now you could say it's double hearsay or layered hearsay if it's him simply repeating what Officer Darling told him. But either way, it's in this.
I appreciate that. I just wanted to know the correct argument here. And I would then indicate in this instance that that I would argue against the fact that it would be hearsay because, again, it was just used as the lien was used as the probable cause to pull the vehicle over, not for the truth of the matter asserted. It was not, the officer, actually attempted to obtain and to investigate further if there was valid insurance. Again, in the state of Michigan, you are required to have proof of insurance in your vehicle. If you do not, it's a tollable offense. So I would state that it would not be deemed, it could be deemed hearsay for the purposes of an exam, but it would not be a case where it is not probable cause for an officer to pull a vehicle over and further investigation, which in this particular case, we do not know about one that we are referencing to, People versus Cianetta Hannon. If that was done, but we very clearly observed today via video and the testimony that our officer indeed investigated and did not take lien at its word, and therefore I would deem that it was not hearsay. He did investigate further.
Okay, Mr. Burns, you can briefly.
Just briefly responding to the claim that this is for the effect on the listener, clearly being admitted for the truth of the matter asserted, because it's the only thing to justify the stop.
So may I, if you have further questions on this, otherwise I'm happy to do our bind over argument and allow Your Honor to make the decision.
I'm sorry, you need to do your, I was ready to go.
It's okay. No, it's okay. We're doing it a little different today, and my apologies, Your Honor.
No, I just had
My
questions
fault.
with this case. The facts are very simple. Whatever.
Yes. Your Honor, the people moved the bind over on count 1 weapons carrying concealed, as well as the added charge of count 2 resisting and obstructing an officer, and that code is MCL 750.81B1. Your Honor, it would indicate that We had spoken briefly about the events that transpired that the officer testified to, as well as what we observed firsthand through the body worn camera video that was shown. I believe the biggest issue in this case right now is the fact that the defendant was pulled over based on information that was provided in lien. That information was that his vehicle did not have insurance. The people argue that this is probable cause to pull a vehicle over. Now, is it probable cause to search his vehicle? I believe that that is a question of fact for a true fact or for your honor in this case. However, that is not what occurred here. As we saw in the testimony and in the video, our officer approached the defendant, he ID'd this defendant as the driver, and asked him immediately for insurance. He did provide his license, he provided some information about the vehicle, but at no time could he produce insurance. The moment he is unable to produce insurance, which he is required to do in the state of Michigan, that gives the officer the ability to tow the defendant's vehicle. He indicated to him, and if I may back up a little bit in regards to count 2, we actually watched this transpire, and we watched on numerous occasions where the defendant actively resisted all commands from the officer. He asked him to get out of the vehicle several times. He refused to get out of the vehicle. He questioned the officer as to why he needed to get out of the vehicle. The officer gave him an answer and told him, because I am impounding your vehicle. You need to get out. He refused, kept refusing to get out. The officer actually told him, you are resisting. This is a resisting charge. And then he still continued to not get out of the vehicle. That is why the people felt it necessary in this case to add count 2, resisting and obstructing. At no point in time did he ever produce the insurance, so we believe that the impound is proper. Once the officer decided to impound the vehicle, which he did state to the defendant he was going to do, he is able to do an inventory search. Not able, he's required. That's for not only the officer's liability, but also for the safety of the defendant and any goods that he has in there. Inventory is always done when, or should be always done when a car is impounded. The car was impounded. The testimony indicated that a ticket was written for no insurance. I believe the insurance question is beyond probable cause. This is a question for a true fact. And we believe that probable cause has been met on both count 1 and 2 and ask that he be found out. Thank you, Your Honor.
I'll be brief. Our chief argument is that there's no admissible basis for this stop because all we have is hearsay about results of a lien search. We do not have any documentary proof of those lien results. If Your Honor disagrees with that argument, we would nonetheless argue that he should, for one, not be bound over on a charge of resisting arrest. This was a conversation, an investigation that was ongoing between an officer and Mr. Abbott. He was searching for his insurance upon request of the officer for just a few minutes. And then while asking for a little more time to search for that insurance, was told to step out of the vehicle a few times and eventually did without any use of force. He submitted to being put in handcuffs. Really, that's not enough for resisting. And in terms of the firearm, even if the stop were valid, which I continue to argue that it's not, we call this the product of an inventory search. We did not hear any testimony that Officer Greer followed inventory search procedures. This seemed more like a general rummaging, where after not having seen a firearm before, goes back to the car, grabs a firearm. You don't hear anything else, nor is there anything in the reports about following inventory protocols. No other items were remarked to have been found in the car, which is the ostensible purpose of an inventory search. And I will just note that in terms of whether lack of insurance was the basis for this stop, Officer Greer testified that to the best of his memory, there was a ticket for no insurance issue. That's not noted anywhere in the reports. And I have no indication that any such ticket was ever issued. But chiefly, there's no admissible basis for this stop. Anything found that occurred after the stop should be suppressed. In this case, should be dismissed.
Brent, I don't want to drag this on, but just in case there's any question of my adding the resisting, obstructing, I would like to just read into the record the actual jury instructions for this charge that the people are asking you be bound over the additional count 2, stating here, quote, the defendant is charged with the crime of assaulting, battering, wounding, resisting, obstructing, opposing, or endangering a police officer who was performing his duties. To provide this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. This, of course, beyond a reasonable doubt is a trial. First, that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered an officer who was an officer. It then further goes in further in parentheses saying the defendant must have actually resisted what the officer was saying. But physical violence is not necessary. I know that there was some questioning along these lines, so I wanted to point out that people are not indicating that there was any type of physical violence or anything like that. We observed the defendant firsthand via video resisting. That is one of the options. He doesn't have to actually assault, he doesn't have to actually batter, but he has to resist or oppose commands that are given by a police officer during his normal course of duties, and asking him to get out of the vehicle multiple times after indicating he's going to impound the vehicle is actively resisting or opposing. Nothing further, Your Honor. Thank you for the time.
All right, so we heard from Officer Greer, the one witness for the people, that he's officer with DPD, Detroit Police Department, for about 3.5 years, and that he was in a semi-marked vehicle, still visible with police on the car, with the same color as the vehicle, also in a modified green pants and black vest with police, and that he was conducting a routine patrol traffic stop, where he observed the vehicle with no insurance. He stated that his officer, or his partner, ran a lane, and that he observed the results of the lane as well in the vehicle. That the defendant, Mr. Abbott, was operating a Chrysler 300 vehicle. Officer Greer testified that he told Mr. Abbott why he stopped him and asked him out of the vehicle. Prior to that, asking him for insurance, proof of insurance. We did see defense exhibit A, excuse me. It did show the interaction between Officer Greer and Mr. Abbott. So I know this is drawn out, but the one piece of testimony that is really the change that matters to this case is Officer Greer's observation of the lane results. Mr. Martin, I appreciate in this case that you have provided from Judge Knapp, People of State of Michigan versus Shawnetta Hannon. The facts are very similar. The one fact that mattered is that Officer Greer did see the lane results himself. That his partner did not have to solely tell him what was found off the lane search in the vehicle. Officer Greer stated that he was able to see the computer search himself. So for that reason, I do not believe that this hearsay that Officer Greer operated on to operate or to stop Mr. Abbott. And we know in the state of, or not even just state of Michigan, Supreme Court said that officers can do and run random plate searches as license plates are public view and can be run for any reason. We also, or state law says that here in Michigan, you do not have insurance, that vehicle cannot be operated on the road. So, let's see, where do I start? I do believe, this is a probable cause standard, so I do believe there's enough to bind over on what has been charged. I am not adding the resisting obstructing charge for the simple fact that the video did show, which I'm glad was shown, that Mr. Abbott was attempting to find his insurance. Although it was not produced, he was attempting. In Michigan, we provide electronic proof, and that may take a little bit more time. He looked in his glove box to try to find insurance. He called his brother to ask, if he tried to find on his phone. He was not successful. But I do not think that he was resisting and obstructing. I believe that he was panicking and trying to find insurance so that he did not have to step out of his car. He was not successful. So I'm not going to add the resisting obstructing charge. I am going to bind Mr. Abbott over on the original charges, however. Once again, it's the probable cause standard and the case that Mr. Martin has provided provide some insight as to how these cases are brought forward at the probable cause standard. But the key fact here is that Officer Greer did see the results of the lane search, so that it's not hearsay as to what the officer found when he ran the plate. I think that's the only issue I had, and once Officer Greer did say that, I feel more comfortable binding it over. And then, of course, there was no issue about possession of the gun. Mr. Abbott was the only person in the vehicle. And if Mr. Martin had any issues with that, you can bring it up, of course, prosecuted Third Circuit. So with that, I am going to bind Mr. Abbott over to Third Circuit Court on the original charges. And your arraignment on the information will be January 26th at 9:00. Anything else from either party?
Nothing further. Thank you.
Okay, sorry.
Thank you for hearing us out, Judge.
Your Honor,
Okay, we are on the record on the people of the state of Michigan versus Tyra Bolden, case 22-60284. Ms. Bolden is charged one count of malicious destruction of a building, $1,000 or more, but less than $20,000. Today's the date set for a preliminary examination. Appearances.
Good morning, Your Honor. Danielle appears from behalf of 385495.
Good morning, Your Honor. Name Thunder Service by Summers Brush, number 85828, appearing on behalf of Tyra Bolden, who is present in the courtroom today.
And Ms. Bolden, can you state your full name for the record, please?
Lene Bolden.
Thank you. Good morning. And are the people ready to proceed?
Your Honor, I was just provided information from the OIC who happens to be in the courtroom and can go on the record with a tad bit more details. We were ready to proceed, or what we thought to proceed. However, he confirmed today with complaining witness and a secondary witness that they no longer wish to prosecute on this matter.
Okay, then officer, can you state your name for the record and give me a little more information about that?
You can come right over here. So
Detective Joseph DeCicco.
Good morning. And Ms. Paris mentioned that the complaining witness does not wish to proceed.
That's correct. Yep, I just spoke to both of them regarding this incident, and they said that they're gonna handle it and address it as a family matter, so they're gonna settle it that way.
Okay. With that, I'll dismiss without prejudice. If people are not ready to move forward.
Thank you, Your Honor.
Thank you. Your case has been dismissed.
Officer, for, can you just spell your name, for me, please?
JOSEPH.
Okay. Can you repeat that?
Out of your way.
Morning, Judge, how are you?
Your Honor, people need a moment to check the witnesses if the staff also needs a moment.
No problem. Thank you so much. And the, talking is Tasha.
When you smell the Detroit holding.
Okay, that's the whole, okay.
If this one right here, there's an interpreter on it. I don't know what's on that.
Right, okay.
They'll be behind it.
Thanks, Lord, I kind of know you.
Okay, we're on the record. This is the People versus Kalan Jacoby Epps, case number 2260691. Mr. Epps is charged with 1 count of weapons carrying concealed, felony commission with motor vehicle adult advisory. David, except for preliminary exam appearances.
Good morning, I'm Danielle Parrish on behalf of People P85495.
Your Honor, please this honorable for Larry Pope on behalf of Kevin Epps, who stands to my immediate right. Mr. Epps, state your name for the record, please.
Now, people ready to proceed?
Your Honor, my apologies. At this time, the people are going to move for an adjournment. As you know, I normally would not do so. After speaking to the officer in charge is indeed here. And our necessary witnesses, however, have failed to appear. They were subpoenaed on the 19th of December. The officer in charge has indicated to me that she feels that the officers will be available for a brief adjournment. The reason she has indicated, you can speak to her personally, is that they are both ill and that they both called off today due to being ill. Otherwise, I would not normally ask for an adjournment as I am aware that the docket is clogged. Trying to avoid these.
Okay, Officer, can you put your name on the
My name is Detective Pamela Smith. Good morning.
Good morning. And can you provide a little more information about your witnesses or the witnesses?
Yes, ma'am. I called both Officer Logan and Officer. My knowledge called the station and stated that they're not feeling well. I did not.
Okay, thank you. Mr. Paul? Anything to that?
Yeah, Judge, we asked the matter be dismissed without prejudice. I don't know. I don't know what their procedure is. I mean, I don't. Seems the detective had to call them versus them reporting that they're not going to be present, especially when they know that they got a subpoena.
Okay, Ms. Parrish, I know you don't do it often, but I am still going to dismiss without prejudice, because both complaining witnesses are not here.
Understood, Your Honor.
You're all set?
Thank you.
I will sign dismissal. Please say your name, sir.
Where you looking? Yes.
All right, we're on the record. This is People versus Barry Hawkins, case 2259415. Mr. Hawkins is charged with one count of weapons carrying concealed today, the day set for a preliminary exam. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Corey Hawkins. Mr. Hawkins is standing directly behind me. Mr. Hawkins, would you put your name on the record?
Where you looking?
Good morning.
Good morning.
Okay, are the people ready to proceed?
People are ready to proceed, Your Honor.
Okay, I believe, motion.
Your Honor, we're going to move to dismiss based on a discovery violation. And just to give the court some procedural background, we initially requested discovery through the prosecutor's office, their discovery portal back on September the 2nd, 2022. This case originated on the CCW docket before Judge Robbins. We appeared on September the 9th, and I requested on the record that all discovery be tendered. On the 12th of September, I received paper discovery. That paper discovery indicates that there, on the investigative report, that there is body worn camera footage available, which I had not received. On the 21st, I emailed to follow up the prosecutor in that courtroom, APA Major, asking for the digital discovery. He emailed a link that contained two dash cam videos, but none of the body worn camera footage was included. We ultimately ended up on Judge Williams' docket on October the 20th, 2022. The initial PCC was held here. I again requested the body cam footage that time. Which date was that? October the 20th. And Judge Williams ordered that it be tendered. On November the 3rd, the adjourned PCC was held. I again requested body worn camera footage. I believe it was APA Lewis who was present for that. The PCC was again adjourned on November the 17th. Another PCC was held and a different prosecutor was present. She represented that they had been attempting to get in touch with the OIC to request a full body worn camera. And at that time, Judge Williams stated that if the discovery was not provided by the next PCC date, that he would dismiss the case. At that next PCC date, which was December 1st, APA Decker represented to me that he entered the court that he had the full body worn camera footage and would send it to me. I did not receive it. I emailed yesterday again to follow up, and none of this is Ms. Parrish's fault. She is, I think, the sixth prosecutor probably to put hands on this case, and she did follow up and she sent me everything which she found available on the case. What we're missing is body worn camera footage of, there was two officers that engaged with Mr. Hawkins. One of whom actually got out of the scout car and engaged with Mr. Hawkins on foot. And it's alleged that Mr. Hawkins had an interaction and I guess he's the one that tackled Mr. Hawkins. We don't have that body worn camera footage. We have no footage from the engagement of that officer and Mr. Hawkins. We have about a 26-second clip of the, I believe it's that officer getting out of the scout car, and that's it. And then we have footage after Mr. Hawkins is on the ground, the officer, and nothing in between. And so that is what we've been requesting this whole time. That is what could be the most relevant piece of discovery in the case. MCR 6.201F provides the discovery provided in 21 days of request. Mr. Hawkins has a constitutional right to present a defense. That was body worn camera footage. I can't be effective cross-examining an officer. There's potential impeachment material there, and we can't see what actually happened. MCL 780.3162 requires that law enforcement obtain that audio and video recordings when they're the subject of an ongoing criminal investigation until such time that that page is disposed of. And MCR 6.201J allows this court to enter any order it deems just under the circumstance. People v. Williams, which is 188 in chapter 4, it's a 1991 case, gives the court broad discretion to sanction a party for the failure to comply with discovery, and it includes dismissal. And I think in this case, Your Honor, the circumstances are pretty egregious. We have requested this discovery over 6 or 7 times. And it is not discovery that is tangential to the case, it's the most relevant piece of discovery, and it's routinely turned over. So I don't understand why we don't have it, why it's not been turned over still on this day, which is 3 months later, 4 months later.
Anything for the people?
Yes, Your Honor.
Thank you.
First of all, I apologize for discovery delays. What I have learned in the last 24 hours, Your Honor, since I got involved in this, is that discovery was sent once it came into Judge Williams' court. However, it was not the discovery specifically, as you heard defense indicate. There is a particular clip. This was a misunderstanding, as we provided everything that we have. We also reached out to the OIC and asked them to provide digital. At this time, I do not believe previous APAs were asking for something specific, but rather saying body worn camera, body worn camera. And this was uploaded and it was provided. However, as of yesterday, when I got involved, it became very clear, thanks to defense, she sent an email indicating what she's indicated on the record today, that there is just a particular, well, there's not just that she's looking for that, but that is a particular part of the video that is believed to be missing. I got involved yesterday after this was clarified from defense yesterday. So I understand that, at the last PCC, whether that was November 3rd or whatnot, but since then, there has been, it appears, no communication that there's a discovery issue. The moment it was clarified yesterday, and we had an opportunity to get on it, we contacted the OIC several times yesterday. Last night, after midnight, additional discovery was uploaded. Within 24 hours of us, less than 24 hours of us reaching out and indicating what it was. At 3 in the morning, I was actually sending that to defense in order for there not to be a delay, Your Honor. But again, this particular error was only brought to our attention, when I say our, myself and APA Kirker, that there is a problem yesterday. And as of yesterday, we jumped on it to fix it. And when I say fix it, I'm happy to bring the OIC in. I did go out to speak to her because the defense was kind enough to indicate to me that even though I sent everything over to her in the middle of the night, there's still that one little part that is apparently missing. The OIC has indicated to me that they have provided everything, that there is nothing that they have that's further. The officer indicated that that from that point, from them exiting the vehicle to the defendant supposedly falling to the ground, wasn't even 10, 15 feet, quote, what he told me. So they're trying to figure out why the body worn camera didn't trigger what happened, but they have indicated that she will come, the OIC will come on the record and state that every piece of actual video that they have has been officially provided, and that defense now has everything, and that there is nothing else that can be provided. Therefore, the people would object to a dismissal because we have provided everything. There is nothing that we have. And actually, at no point in time have we ever had anything that we did not provide it. The moment we received something, it was immediately shared with defense. But if you wouldn't mind, Your Honor, I would like to bring the OIC, just because myself, I want to get this resolved as well. If there's actually, I want her to go on the record to indicate that there is no outstanding discovery in this matter.
So that's my only question at this point, does it exist?
Right.
So
Would you mind if she comes on? 'Cause she told me that it doesn't, but I would rather her state it for the record.
and why it does not exist. Okay.
Thank you, Your Honor.
Let me just step out and her.
Thank you. say that too. Just get your phone. Hello. Your Honor, this is officer in charge. Please say your name for the record, please. Good morning, Detective Vanessa Burke.
Good morning. Okay, so we are scheduled today for a preliminary exam. Defense counsel has brought to the court's attention that there is a specific time period from one of the officers' body cam footage that she has not been able to review. The people have stated that she has provided everything that's available. Can you please relay to the court, one, if all the discovery has been provided for the body cam footage? And two, if so, why the footage that defense counsel is mentioning is not available? So I guess we'll start with, did you provide all the discovery, digital discovery? Yes. And secondly, defense counsel is mentioning that there's one officer whose body cam footage in a critical time that would be very helpful for defense counsel, probably moving forward, is not available. Are you aware of that? So I guess specific, do you have the officer's name?
It's Officer Flannel. Officer Flannel was the officer that engaged with Mr. Hawkins outside of the scout car. And we have what is labeled as his body worn camera footage beginning while he's in the car. And then we have a clip that's labeled as him at the end of the interaction. Theoretically, the body worn camera footage, the body worn camera turns on the beginning of the citizen encounter and it runs and records the whole thing. That is not what happened apparently here, because I don't have the middle clip, the clip of the initial engagement with Mr. Hawkins.
Your Honor, I'm just showing, OIC asked me to pull up evidence.com. So she could reference video. Just so I can make sure I understand. You're saying the video from, so I uploaded Officer Pierce and Officer Flannel's video. And you're saying the video from there was a dash cam video, which is the video that shows the initial stop and turn the corner. And they proceed to get out of the vehicle.
Correct. The dash cam footage shows the initial scout car stopping and folks moving off camera where the action takes place. Okay. To the right of where the parked vehicle was and where the scout car is parked.
I'm sorry, can you speak up?
Can you do that last?
I'm sorry, yes. The dash cam footage is not helpful because the action takes place outside of the footage of the dash cam, or outside of the range of the dash cam.
Okay, so just on the record, all of the video starting from the initial date of the case, which was August 30th, 2022, the video that was uploaded, and then there was a video that was uploaded also on November 30th of 2022, and then I re-uploaded again on January 11th of this year. So without having looking at all of the video now to see which one she's saying that's still not there, I've uploaded everything from the dash to each individual officer in evidence.com. So I'm not sure which one she's speaking of that, but we're still missing. So after reviewing what you received yesterday, is still something missing?
Yes, I have 4 videos. And I outlined exactly what those videos are multiple times by email, but this parent got the final email yesterday, and it tells you, states specifically that Officer Flannel's body worn camera footage from his interaction with Mr. Hawkins, and it is a very brief time.
Yes,
but it's missing. It was not, either his camera didn't record or didn't upload. I don't know why there would be multiple clips from one interaction of a very short period of time of one officer, but that's apparently what we have. I have 4. I've only ever received 4.
Because 4 was original, but then additional, so 3 were uploaded on January 11th, like she said.
I had 4 videos that
So
directed
I don't know
yesterday.
if they're.
So you don't have video from August 30th?
It would have been yesterday,
November
but
30th?
it would have been 3 a.m. this morning. So technically it was today that I sent.
I extracted them this morning. And yeah, so 2 of these are the same. These 2 are exactly the same. That's Officer Perry. This is a 26-minute or 26-second clip. And these are dash cams. One of them is not for this case, I don't believe. The other 2 are identical dash cams. They're 4 different videos.
Your Honor, I would still move that dismissal would be inappropriate because as the OIC has indicated, she's uploaded everything. At this point, I mean, if you want to question why, an officer's video didn't start recording 10 seconds before, something like that, we could refer to the OIC on this matter. But I would like to point out that she, and let me just question the OIC if I may. Is there any possibility that there is additional video evidence in regards to this case that you have not provided?
No, ma'am. In addition to reading the email that she's speaking of, because I did see the email, I went through each individual video after I uploaded it, just in the hopes that I was making sure that I was providing everything that she was asking for. So without having to actually go through each video now to say, in particular, this is what she's looking for. So there's the dash cam when they're in the car, they approach the corner of 7 Mile, Backside Street, and they're turning the corner. You do see some gentlemen parting ways. That video, and then you have the video where there's the interaction. So there's no in between where Officer Flannel's video was on and then it wasn't on, because it shows him interacting completely with his partner during the apprehension of the defendant. So there's no in between. And again, without having to actually look at it, because I looked at all 7 again last night to make sure that I wasn't, even if it was a duplicate, I still resent what I sent initially back in August.
Right, so at this time, if there, I want to make sure that defense is also very comfortable with this. I do not believe at this time it's that any violation that requires a dismissal has happened, because she has been provided, it has been on record that everything that the people have had has been provided to her. The only suggestion the people would have is if there's a brief adjournment for a couple of days so that the OIC and defense could go over and because we'd be wasting the court's time to go through all of it right now.
I agree with that.
I don't think that either you all, OIC or prosecutor, Ms. Perry, I should say, because it seems that this has passed around several times for everybody. And for the defendant to say, this is at this point, I believe, the 6th request for the discovery. I'm not sure if it's a violation of discovery based off of 2 parties present. I don't know if this is an issue where everybody has cut off or not. Coming from traffic docket, I know there's several times that we have issues. We had issues with discovery of body cams being deleted, and having to do evidentiary hearings with that to determine whether or not there was a discovery violation. I don't feel comfortable with where I am today, based off of what I've been told, because I don't know myself based what is missing. And the defense counsel is adamant that there's a part or segment that she believes either is no longer available, deleted, or is still out there. I just don't feel comfortable with the defendant having to have an exam without all of the discoveries that she believes should be available. And I know that you said, fair said, all has been provided. But the
this question about the most important interaction between the defendant and Officer Flannel has been, or not available. And or, I don't know, if it was a dysfunction or dysfunctional body cam, I'm not sure. So I'm not inclined to move forward. And I don't want to dismiss. I want to see if the body cam or the explanation as to what happened, or if it with Officer Flannel. Can you speak with Officer Flannel the next 2 days?
Absolutely.
Okay.
In addition to that, I will definitely make sure I understand what the defense is actually asking as far as the video.
I'm happy to sit down with you.
Absolutely.
Great, so that seems to be like, it's just too many parties that were involved in this.
And then, and as far as like, we're here now, and I know it's an older case, like if there was possibly where some video, maybe it was there and then it wasn't actually. I don't know how that system works, because I know she wasn't the initial defense attorney that was on it.
I was, I had
Okay.
a meeting.
From an instance.
Okay.
Okay, so.
Oh, I hate to ask for, or put another jargon on this case. How much time? 2 days?
I'm thinking maybe get today's days.
What day next week do you want?
Yes.
I don't have any availability next week until next Friday. I have evidentiary hearings at the next week.
And I won't be here Friday, and I want to be here. Because I'll let you pick the date, since you have been trying very hard to get this information.
My next really good date is the 23rd, if the court has any availability that day.
That's fine, we'll make it. Should we schedule this for an exam?
Which,
The
yeah,
23rd.
which day is it? I don't have a problem with that. However, I do want to indicate that I am not your courtroom prosecutor on the 23rd. I can convey, I will keep in this, APA Kirker has been involved in this. I will make sure that, she's shaking her head. If you want me here, I'll be here.
But here's the thing, I don't think the issue really is with you, Ms. Perry. I think it's between BPD.
Yes, and I'm happy to hear that they can
Absolutely.
hopefully resolve it today, and then the OIC, and I can talk later on today. And I'll be in constant contact, even if I'm not here on it, but we'll get it resolved by the 23rd.
And based off of whatever happens on the 23rd, you want to set it for an exam and then
Perhaps we should set it for an exam. If it ends up needing to be an evidentiary hearing, then I'll just be in touch with Ms. Parrish and she can have the proper parties subpoenaed that way.
okay. Either way, we'll be ready to go.
Yes, thank you.
Thank you, Your Honor.
Thank you.
Is there a time that you have for the 23rd, Your Honor?
Okay. We can do 9:30.
That works.
9:30?
You're all set.
You're gonna follow me.
Yes, there you go.
Judge, Your Honor, I didn't realize, I'm getting ahead of myself. I didn't realize that the 23rd is not this Monday.
You will be here.
Right, right.
That's where
I might actually be here.
So it's
So we'll see. Either way, I'll stay on board until we get it resolved.
Okay, well,
Your Honor. You don't need nothing, do you? Serena, you okay?
The volume low.
Wait a minute, I can't hear you. Hold on, let me turn my volume up. You say what, Judge?
We're good. We're just waiting on the next party.
Okay, and I did call that other case. I called several times. Still, no one is answering and no voicemail.
Okay.
Okay. All right, I'll check back with y'all later.
Okay.
All right.
McCants, he's in there.
Okay, we're on the record that the people in Michigan versus Walter McCants Jr. Case 2260212. Mr. McCants charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault. This is an habitual offender fourth offense notice. Today, the date set for a preliminary exam. Appearances.
Morning, Advocate Ellen, there's on behalf of people, P8495. And good morning, I'm at this most honorable court. In the Shawn Neighborhood Defender Services, P59167. And it is my pleasure to represent Walter McCants, who is here in person, standing behind me.
And Mr. McCants, please state your full name for the record, please.
Walter Rudy McCants Jr.
Hey, is my understanding, well, I guess I should ask, is this going to be a waiver?
It is, Judge. As of this morning and previously, Mr. McCants and I had an opportunity to go over the discovery in the matter. The people are ready to proceed in the case. I've explained to Mr. McCants that he has a right to a preliminary examination where the people would need to prove by probable cause that a crime has been committed and who may have been involved in that matter. After that discussion, Mr. McCants has agreed to waive his right to a preliminary examination, understanding he will be bound over to the circuit court.
Okay, Mr. Shawn, you did my job. Mr. McCants, is that correct what your attorney just stated?
Yes, ma'am.
Okay, and there's no objection from the people?
Your Honor, there's no objection. I just want to know, due to the severity of the charges, the people did go forward, speak to the complaining witness on the case, to let them know that a waiver is being had. The people would just like to note, and please let me know whether you'd like to do this before or after, but I would like to revisit bond in this. Maybe not so much to change it, but just to confirm some of the requirements of the bond. And we would like to add a little part if possible. I have spoke to defense on this matter as well. And I do have the OIC here in the courtroom to verify both that we did confirm that the victim has no objections to a waiver, as well as what I'm going to discuss regarding bond.
Okay, so first, I believe Mr. McCants' waiver is really understanding the involuntarily given and now to bond for.
Thank you, Your Honor. We understand this was prior to myself and Your Honor coming into this courtroom that initially there was a higher bond in this matter, but by Judge Williams, this was reduced to a personal bond with tether. There has been some allegations, not by the victim, but by a family member that possibly there had been, whether it was an intentional contact or accidental contact, we can neither confirm either one. Therefore, I'd like to just put on the record while this case moves forward, that there be no contact from the defendant to not only the victim, but any of the victim's family, that there be also a certain amount, I don't know if defense wants to indicate, but that he stays away from also their residence. And note this on here, I believe that it's not any change except for him not having contact with the defendant's family.
And if I may respond, there is a tether in place. It does go directly to the complaining witness's house. There has been no, just so the court is aware, there has been no tether violation Apparently, the complaining witness's wife believes that she saw him, Mr. McCants, that is, at, I think, a grocery store, is that right? And in truth, Mr. McCants and the complaining witness themselves have only known each other for 2 days. And so I don't suspect Mr. McCants even knows who the complaining witness's spouse is. And so I guess my only hesitation is that Mr. McCants has no idea who the family members of a gentleman he's only known for 2 days at the time of the incident are. And so I just don't want any violations with people that he has no understanding of who these people are.
And
Obviously, if he goes near the house, huge violation, and we don't suspect that's going to happen.
And Your Honor, and maybe we could state intentional or something of that nature so that the people would have to show that it was an intentional contact. The allegations were that, again, can't be proven, therefore I'm just stating why we're putting this on the record. But allegedly that the defendant was reporting the victim's wife. So obviously we can't go back, but I would like to indicate if we could put any intentional contact, something like this that could give rise to believe that he was intentionally making contact or knew who it was.
Okay. So Mr. McCann, based off of what I'm hearing, if you are to run or encounter unintentionally at a grocery store or out in public, anyone related to the case, meaning complaining witnesses, if you even know the spouse or whoever else is involved, can't finish. You are to just not engage. I'm not saying that you filmed. I don't know. I wasn't there, but I'm going to add to no filming, no engaging, no conversation. Okay. And as far as intentional, it's the same no contact order. You're not to contact the complaining witnesses. That means social media, telephone, letter, through other people. You're not to visit the houses of the complaining witnesses or where the incident took place. Okay.
That makes perfect sense.
So there's no bond violation here, but just clarifying that if you do, because Detroit is, in my opinion, a small city, if you run into anyone who's involved in the case, to just walk away. Even if they engage you, just walk away and just make things easier until this is resolved. Okay.
Thank you so much, Judge. No. No. She just. I know, I said that. I understand. So she agrees with us. Okay.
Mr. McCann, I said, if you encounter anyone, meaning you don't know, you have to know you're encountering something. There's been no bond violation, so you're fine.
I'm not saying that, Your Honor, I'm
Your
saying.
attorney is advising you not to speak, and I think that you should listen to your attorney.
Thank you very much, Judge. And our AOI date is in 2 weeks, Judge.
I'm sorry, I'll get right to have a good day. The arraignment on the information would be for January 26th at 9 o'clock across the street.
Outstanding, Judge. Thank you so very much and a lovely day to you and your staff.
You and her, have a good day.
Oh, and just so you guys know, that should go to Judge Green, which is where. Thank
Nice
you.
seeing you.
Always lovely to see you as well. All the trouble I can cause.
Sorry, I need your assistance. Officer, do you mind if you make favor while I convey something to you, Your Honor?
Okay, we're on the record. This is case 2258508, the people versus Ikat Hashim. Mr. Hashim is charged with one count of home invasion, second degree. Today, the date set for a preliminary examination appearances.
Good afternoon, Your Honor. Daniela Church on behalf of the people, P85495.
Good afternoon, Your Honor. May I please report? Anthony Lewis, 43876, on behalf of the defendant that is present in the courtroom.
And, did I say your name right? Mr. Hashim?
Yes, ma'am.
Can you state your full name for the record?
Kai Hashem.
Thank you. Good afternoon.
Good afternoon, Your Honor.
Okay, so today the day set for a preliminary examination. We had a lengthy sidebar, all parties, and it's come to my attention that this preliminary examination started or began with Judge Williams. And also, we have an issue with the Arabic interpreter today, that we were running very late, so the court was not able to hold the exam in time scheduled. So we will be rescheduling the preliminary exam. More importantly, I will be rescheduling this case tomorrow to a probable cause conference at 8:30 a.m., which Mr. Lewis will Zoom in so that we can discuss when Judge Williams can hold the preliminary examination. Also, there was discussion that the former prosecutor on the case is no longer here, AKA Lewis, and Ms. Parrish is going to handle that case, I believe. And I will, in the meantime, between now and tomorrow morning at 8:30, talk to Judge Williams to see what date will work for continuing this exam. Is there anything that I missed in our sidebar that needs to be put on the record?
No, Your Honor, I think you stated it all. I would just note that either myself or APA Kirker will be able to do it so that we don't hinder any days, the availability. So whatever day is set would be fine with us.
Okay, Mr. Lewis?
Judge, you did not miss anything of importance.
Okay. All right, with that, I will change this to a probable cause conference for tomorrow at 8:30. I will see you then, and I will talk to Judge Williams about a date in which he can hold the examination. And then we'll also request the Arabic interpreter.
Thank you, Judge.
Thank you, Your Honor.
You all have a good rest of your day.
Thank you, too.
Good afternoon. You are here for a traffic matter on Zoom. You are in the wrong courtroom. Judge Williams is going to be handling your case in courtroom 332.
Hello?
Please take the Zoom information now so you can log into the correct courtroom. The Zoom information for courtroom 332 of Judge Williams now is 360-332-0000. So go ahead and log in to courtroom 332 if you have a traffic matter.
Let me see if I can get my phone set. Hello?
Mr. Fountain,
Yes.
get the
I can hear
information
you.
I just shared?
Pardon?
Did you hear the information I just shared to zoom into courtroom 332?
No.
Mr. Jackson, Ms. Fowler, Mr. Morales?
Yeah.
Morales is here.
Okay, you all are in the wrong courtroom. I am now doing felony cases. Judge Williams is handling all of your traffic matters.
Judge, say it again. Judge what?
Larry Williams, the Zoom information is 360-332-0000.
Thank you.
You're welcome. Ms. Fowler, okay. Attorney Cripps, good afternoon.
Good afternoon. How are you?
I'm fine. How are you doing?
I'm doing okay.
Let's see here. Here for Terrence Jordan.
Yes,
Okay.
there's some kind of hearing on whether a witness can take the Fifth Amendment.
Okay. I think Judge Williams is handling that. Hi, can I help you? Hello? Your name, please? Okay, sir, I'm gonna buzz you in to pull the door for you.
Yes, sir. I'm sorry.
This is a whole, right?
We're still trying to figure out that. There's a little confusion, so we're just trying to figure it out. And I'm sorry, Natia Scott.
Okay. That's what I thought. So Ms. Scott, you're handling those 2 o'clock?
Yes.
So did Judge Williams, did Judge Williams start this with you?
Yes.
All of it?
Yes. And I like, he said it's for 10 minutes.
Okay, I just what I thought, I just wanted to make sure.
Yeah, I don't know if he's coming up here or if you guys will us go down. That was nice.
So it depends on what, if this is a waiver or dismissal, we have to get out the way by 2 o'clock.
It's actually an adjournment. She doesn't have to file. There was a mix up in, with our new system, PK. It's just a mess with our new system. And so subpoenas were sent out magically with PK, but the trial process, general trial process does not have a file or any notice of this case. I didn't know how that out.
So it won't be held today.
No.
Okay, Mr. Cripps, Judge Williams is going to be handling your matters.
Okay, Judge.
Hopefully I can get out your way.
No, I just put on the edge of that phone and I didn't want to.
Oh,
It's on the spirit.
I'll put that over here. Okay, okay.
I was trying to keep getting way.
You have a, you have all these files. Washington, after, so Washington is. Chief defendant number 3. Probably. And Washington is defendant number 2.
Hello? Yes. Good. You're out. You know, we have court tomorrow. Yes. Well, I don't even know what he's gonna say. At the house, he wasn't even there. Well, we'll see tomorrow. I can't speculate what's gonna happen ahead of time. What do you mean? Well, yeah, I know, I didn't, but we don't know what he's gonna say. I don't have any statements from him. I don't have any interviews from him. I don't know what he's gonna say.
Mr. Van Horn,
Yes, ma'am.
good afternoon.
Good afternoon.
You're here for a traffic matter?
It's a arraignment.
Okay, so you're supposed to be in courtroom 332. Take this Zoom information down. You're with Judge Williams now.
Okay, let me write this down. Okay, I'm ready.
It's 360
Okay,
332
okay,
0000 or zeros.
okay.
Go ahead and log in now. Take
All
your
right.
hat off, log in to court.
Okay, thank you.
This guy, you said prosecutor had filed. Daniela. Oh, okay. I didn't know. Okay.
So they're gonna make it forward. I'm sorry. Oh, wait, I think I put myself up.
Ron's iPhone, what's your first and last name, sir?
Ron Gwen.
Can you speak up? I didn't hear you.
Ron Gwen.
Lynn, I think.
Yes.
How do you spell your first name, sir?
Korrron.
Sir, do you have a case number or something perhaps, so we can identify you quickly and see where you need to be?
I was here for my brother. His name was Deontay Johnson. I don't know his case number.
Must be a traffic matter.
No.
It's our case today.
Can you say that again?
So,
Okay. He said he's here for us.
so sir, you have to log on to YouTube to watch it. If you go to our
Okay.
website, 36 District Court website, you'll see the option on the left toolbar to view hearings. It'll be courtroom 438.
Okay.
And we haven't started yet, so
Did I miss it?
we haven't started yet.
Okay, thank you.
You're welcome.
Good afternoon, Your Honor.
Good afternoon, how are you?
Oh, taking it day by day.
Yeah. So Judge Williams is going to be handling your client's matter. He should be here shortly.
Okay. Thank you.
You're welcome.
Person that, the attorney? No, the civilian.
Oh, what was his name? Karan, somebody. Karan, I think it was John. Was it Johnson?
I got Gwen, it may not be Gwen,
Oh.
it's kind of muffled, so I got Gwen, he agreed those.
I don't know. I think he said he was his brother, right?
He was here for his brother. His brother
Oh.
is on the 130. Good afternoon. Mr. Washington?
Yes. Can you hear me?
Yes, this is Marquise Washington.
Yes, ma'am. This is me.
Okay, so I have you checked in. We have a matter that we're going to address before yours. Just hold tight, okay?
Okay.
Attorney Friendly, do you want to speak to your client in private before we get started?
Yes, Your Honor. Thank you.
Are these in the email? Why did I do this?
Go ahead and remute, Mr. Washington.
Okay.
You can also turn your camera off until we're ready, Mr. Washington, okay? Just so you can sit a little comfortable until the judge gets on the bench.
Right this way, sir.
Right.
Right.
Okay, we're on the record. This is the people, state of Michigan versus Deontay Juwan Johnson. Calling case 2260558. Mr. Johnson is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm less than murder or by strangulation, count 3, assault with a dangerous weapon, felonious assault, count 4, weapons, firearms, possession by a felon, count 5, weapons, felony, firearm, second offense notice, count 6, weapons, felony, firearm, second offense notice, count 7, weapons, felony, firearm, second offense notice, count 8, weapons, felony, firearm, second offense notice. This is a habitual offender, fourth offense notice. Today, the day set for a preliminary examination appearances.
Good morning, or good afternoon, Your Honor. Danielle appears from the FW P85495.
Good afternoon, Your Honor. Nancy Kessler from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Deontay Johnson, number 80549.
And Mr. Johnson, can you state your full name for the record, please? Good afternoon. Okay, the people ready to proceed today?
Your Honor, my apologies. There was a mix-up with our new PDK system. It had indicated that we had a special prosecutor on the case. That prosecutor had other cases this afternoon in front of Judge Williams. I did speak to that prosecutor. This is not her case. They're going to take the case over. We do have the victims here on the case. However, because I literally, as you call the case, I learned the defendant's name. So I feel it would be unethical for me to just hold this today. I am asking for an adjournment just till tomorrow. We already spoke to I know that the defendant is in custody, so I don't want to delay it any further. So we're able to come back as soon as tomorrow if that works for your honor and defense. I will indicate also that after speaking to the OIC as well as the victims in the case, that if we do hold the exam, the people are prepared to add additional felony charges, including but not limited to discharge into a building, as well as additional AWIN charges and felony firearm charges. So at this time, I don't know what defense is prepared to do, but if they are ready, if they want to hold, that's perfect. Charges again, can you say those charges again that you said you were including but not limited to discharge into a building, Your Honor. I don't know the MCL code onto it. Allegations and the testimony will likely show that the firearm was not just at one person, but discharged into a building, and that had, I believe, a minimum of 2, likely 3 additional occupants in the building, that charges would be brought for each one of those occupants as well, with the additional felony firearm. Again, that would be testimony corroborates what I've been told out in the hall.
Your Honor, obviously this is new information for us. I did have an opportunity to advise Mr. Johnson of that information. At this time, Judge, I would need to further speak with Mr. Johnson in regards to that possibility of adding those additional charges. So if the court wants us to come back tomorrow, then it gives us more of an opportunity to speak, decide on whether or not.
Okay, because he's in custody, I do want to handle this as soon as possible. So tomorrow, 10:30, does that work? Works for the people. The defense can check their schedule.
At 10:30 is fine with the defense.
Anything else?
No, Your Honor, that would be it.
Yeah.
Nothing from the bench?
Your Honor, if a DSU report has not been ordered, I would respectfully ask that a DSU report be
You
ordered.
said DSU?
Yes, please.
Okay, I will have the clerk request.
Thank you very much.
Okay, I will see you tomorrow, Ms. Johnson.
Thank you, Your Honor. My apologies.
Oh, did you look it up?
Thank you.
And if you call tomorrow around 9, if you don't have anything going on, I can tell you, we can start earlier.
Okay.
Because I don't know, it's actually looks pretty good, but it's on paper, so that might change.
If I could, I will try to be here as early as 10, but we'll just wait.
Okay, that's why I said later, so we can all get on.
I will. Thank you for letting me know.
Thank you, I appreciate it.
Okay. It's been a pleasure.
Yeah, Your Honor.
I'm glad. I'll see you tomorrow.
Okay. Attorney Chris, and finally, I'm going to get Judge Williams, who's in the hallway, and we are done with our docket, so you all can get moving.
Afternoon,
Okay. Yeah. Let's go on the front. You want a DSU report? All right, I'm going downstairs.
So you're gonna do on now?
Yes, you are stuck with me.
I can think of worse things to be stuck with. Congratulations, yeah.
All right, I will see you all tomorrow. Okay, Judge, thank you.
All right, have a good day.
See something else or the thing.
All right, this is State of Michigan versus Terrence Jordan, case 2206075001. Also called State of Michigan versus Terrence Jordan, case 220588727701. State of Michigan versus Marquise Washington, case 2205882702. State of Michigan versus Tyrese Huffman, case 2205882703. Date set for preliminary exams and hearings. Appearances, please.
Good afternoon, Your Honor. Natea Scott on behalf of the people, P78816.
And good morning, well, I'm sorry, good afternoon, Your Honor. Attorney Kiana Franulik, P73015, on behalf of Mr. Marquise Washington, who is present via Zoom. Mr. Washington, please unmute and turn your camera on and state your name for the record.
Marquise Washington.
And good afternoon, Your Honor. David Cripps, P34972, appearing on behalf of Terrence Jordan. He's in the courtroom.
Good morning, good afternoon, Mr. Jordan.
Good afternoon.
Good afternoon, Your Honor. Edward Taylor, P57166, Tyrese Huffman. Introduce yourself to the court. Mr.
Tyrese Huffman.
Good afternoon, Mr. Huffman. All right, today is the date set for, well, starting in case 220588270, counts 1, 2, and 3. Today was the date set for a preliminary exam and motion hearing. What's going on?
Your Honor, after last hearing, the people did a little bit more research and filed a motion. At the last hearing, you ordered the victim in this matter, Mr. Juan Kennedy, to appear via Zoom as we discussed the going forward with this case. And then during that time, the people filed a motion, which I think was submitted to this court on December 21st, 2022, informing the court that he could not assert just a blanket assertion of a Fifth Amendment privilege, and that the people requested that the court hold an in-camera hearing. The people are not privy to that hearing, and neither are the defendants nor their counsel privy to the hearing or even have standing to challenge that. But I also submitted the motion to defense counsel just so they could be abreast of what's going on in the case. So after that time, I submitted a motion for you to hold a hearing with the defendant, with the victim and his counsel to determine whether or not he had a valid right to a Fifth Amendment privilege.
Unfortunately, on December 20th, 2022, I was, transferred from this docket. I do not have email access to this court.
May I approach? May I approach, Your Honor?
I missed the motion. I don't have any copy of the motion. Ms. Scott, you can approach. I'm sorry. Can I have that copy, or I should take a copy, photocopy of the
This is the court's copy.
Okay, cool. And then furthermore, all parties, you guys can address, send in your document at Larry.Williams at 36districtcourt.org.
I'm sorry, can you repeat that one, Your Honor?
It's just Larry.Williams at 36districtcourt.org. We need to have this hearing before we go forward. Ms. Franulik, I got an email from you, I think on a different case, indicating some, I don't know if this has any bearing with this matter, that you weren't available to appear in court.
Oh, that was for a hearing on Monday, Your Honor. I was in urgent care. And so this was before I realized or knew that your dockets had switched, but I had your other email address already.
Yeah,
and so that was on a different case.
Okay. Let me do this. I have to set a control date for this to have the hearing. And I'm assuming, at least to read the motion, to figure out how to grant the motion. Mr. Curtis, it's my understanding you have to go as well. Is that correct? Okay. What I'm inclined to do, Ms. Scott, we're here on the 17th?
Yes, at 11 a.m.
At 11 a.m. I'm gonna set this for a PCC at 11 a.m. All parties are waiting for this appearance. The attorneys can check in. I'll let you know what my ruling is on the motion. And if I have to have a hearing outside of this, then we can schedule an exam at that.
Is that live or Zoom?
Zoom. But, you know, as me and Ms. Scott will both be here.
And Your Honor, you said the 17th via Zoom and waiving our client's appearance?
Yes.
Okay.
You do not have to be here for that hearing.
Okay. I have Mr. Washington, but I'll let Mr. Cripps know as well if he doesn't hear us.
Okay, I know Mr. Washington's on Zoom. I was talking to the gentleman in court. All right, see you all on the 17th. I think Mr. Cripps is on another case right now. Thank you. And Ms. Scott, I'll let you know probably tomorrow where I'm at, get a chance to read this and take it from there.
Also,
And Your Honor, for the record, I did send a response, and so I'm going to forward that response to Your Honor as well.
Okay, but Ms. Scott, have one more thing. Go ahead, ma'am.
Yes, there's a memo of law that I submitted as well, but I'll resubmit it to, the court. Defense counsel already have it, but there was a memo of law that I submitted regarding MRE 801 and MRE 804. But in regards to the people's motion, that's an ex parte motion, and so the defendants have no standing to. On that motion.
Send me what you get to the Larry.Williams at 36districtcourt.org.
Your Honor, if I may, what about this motion is ex parte that doesn't allow me to respond because I don't even believe it was listed as an ex parte?
Right here, I have not read anything yet, and I'm not gonna go back and forth arguing right now. So we're gonna look this over, and I'll make my decision. I'll give you a chance to respond in any way I feel necessary, okay? But
Thank you, Your Honor.
I haven't read anything.
Take care, y'all.
All right.
Thank you, Your Honor.
You're welcome. Thank y'all for your application.
Thank you. See you on the 17th. You can log out, Mr. Washington, and you don't have to appear at the next date, okay?
All right.
All right. Bye-bye. And have a good day, everyone. I'm sorry they took you from us, Judge Williams.
Hey, it's
Oh.
complicated. That. It's
Judge?
complicated. But,
Judge,
yeah,
I had some problems with my connection here.
okay,
So
Mr. Chris, explain what went on. So, I guess, there was a motion filed, but because I switched dockets, I didn't get a hold of. I haven't read anything, and I know Ms. Frenulek got a response, but I set this over for a PCC on the 17th, the date that we're all gonna be here, or at least you're gonna be here, for me to catch up on this one. And then I'll set a date shortly after that.
All right, so PCC at what time, Judge, on the 17th?
11 o'clock, which is the same time as our continued exam.
Thank you, Your Honor.
Thank you, Your Honor. Everyone have a great day.
I waived
You
Mr.
too.
Jordan's presence, Mr. Cripps. But
Thank you, Your Honor.
But you know, he has to be here for the
Yes,
in-person anyway. I hope I
that's
didn't-
true.
All right.
Thank you, Your Honor.
Yeah,
Have a
thank
good
you.
day.
Thank you both.
So both motions are up that day, Judge?
It's only one motion, Mr. Cripps, and then the memo of law that Sister Counsel Scott filed, but technically only one motion.
Well, what about the Fifth Amendment motion?
That's the one motion.
Okay, then there's the companion motion of the memorandum in law, which has different issues. Okay, I got it.
Have a great
Thank
day.
All right, you too. Thank you for filling me in.
You're welcome.
Bye, everybody.